The Laws of Blackacre, Property Law. Introduction to Law, Dr. Peter Baxter, Spring Semester 2005. Now, I'd first like to clarify the difference between freehold estates and non-freehold estates. Freehold estates are called so because they give you two elements that are key to understand. Freehold estates, first of all, gives you alienability. That's the ability to buy and sell land. The second thing freehold estates give you is inheritability. This is the ability to give and receive land from an heir or an ancestor, like in a will. So freehold estates give you both alienability, which literally means sellability, and inheritability. You can inherit from others. Non-freehold estates simply gives you the right to use but not abuse the land. Now, think about the apartment rental. That's a non-freehold estate. You don't own the land, you own the right to use the apartment but not abuse the apartment. Now, the simplest kind of freehold estate, and this is what we're going to concentrate on for most of this lecture series, is what's known as the fee simple absolute. The fee simple absolute. Now, these words come from Old English, so there's no modern English equivalent. We use the Old English terms in property law. The fee simple absolute reads O to A and her heirs. O is simply the original owner. A is the first person taking the land. So O gives to A and the heirs of A. O to A and her heirs. Now, we call it a fee simple absolute because O gives to A, and if O dies and A dies, the land goes to the heirs of O. So O to A and her heirs means the land will never come back to O. Now, if it were able to come back to a person, specifically to the owner, O, we would call that the possibility of reversion or the reverter interest. Okay? Now, lawyers, as simpletons, use simple phrasing. O, owner. A, guess who comes next? B, C, D. Okay? So it's simply a way to shorten instead of using people's names. O, owner, to A and the heirs of A, meaning those who inherit from A. Now, in Old English law and in American law back in the colonial age, we had a thing called a fee tail. It read, O to A and the heirs of her body. Of her body. Now, in Old English law, you could write that in. You could write a fee tail in, and it would survive. Meaning, O has the land, gives it to A, and then A can give it to only those heirs that are of her body, meaning that she naturally bore. You're going to hear me say this a lot. By operation of modern American law, we eliminate the fee tail. We find it offensive. We find it unconscionable. Remember that concept, the contractual concept? We find it unconscionable. We find that it's against public policy in the modern United States. So, if a court had an old deed and they came across a fee tail, they simply eliminate it in their minds. Why is it against public policy? Well, heirs of her body would mean that adopted children or stepchildren would not be considered heirs, and A would not be able to give to them the remainder of the estate that she got from O. We find that reprehensible. We do not accept that there should be a differentiation between natural born children and those that are adopted or who are stepchildren. So, how do we do it in law? We simply eliminate or redline the part that offends us. The part that offends us is of her body. So if you look at the property transfer and synopsis that I handed you, or I'm sorry, that I put on Blackboard, you will notice a red line through the parts that offend us, the actual fee tail of her body. So O to A and her heir and the heirs of her body now would read O to A and the heirs, meaning a fee simple absolute. We also have a set of freehold estates we call life estates or legal life estates. The simplest of these is O to A for life. O to A for life. What happens to the land after A has died? Well, it comes back to O. We call that the possibility reversion. Remember I said this, or the reverter possibility. So, O has the estate, gives it to A to enjoy for A's life. When A dies, it comes back to O. Now, let's assume that O is dead. It doesn't matter. It comes back to O and the estate of O, meaning the heirs of O. So even though O is, pushing up the daisies, it doesn't matter because the land will come back to O's estate. One assumption we have to make in property law is that everyone has heirs. Everybody has people that could inherit from them. And the other thing we have to assume is we have to assume that the state and their estate taxes don't enter into it. Now, that's a fiction, of course, but it's a fiction we have to operate with to make these algebraic equations easier to understand. O to A for life, after A enjoys it, the reversion comes back. The possibility reversion comes back to O. Notice, A cannot give it away by will. She only enjoys it for her life or his life. Only for their life, and after the life is done, it comes back to O. Now, to complicate things a little bit, we have an Old English, actually Old English / Norman concept, a life estate pour autre vie, or a life estate pour autre vie. It literally translates a life estate for another person's life. It reads typically like this: O to A for the life of B. Wait a second, what does that mean? Well, quite frankly, B's life is the measuring life. It's the period of time in which we measure how long A will enjoy the property. O gives to A for the life of B. Now, why on earth would somebody set up their will like this? Well, let me just tell you a personal story. My youngest brother has Down syndrome. He has an IQ of a 3-year-old. And anything we give to him would be taxed and taken away by the state. So, say for instance I have a sister. We'll call her Brenda, because that's actually her name. And she's quite close to my brother as well. So say I had some massive estate, and I want to give it to my brother so he can enjoy it. So I am O. I give it to my brother A, his name's Tommy, Pete to Tommy for the life of Brenda. Because I know that he can't live there by himself. I know that he needs a guardian. And Brenda would enjoy it as well. So as long as Brenda is living, she should enjoy my estate, if I had one. So that's why. It makes sense in a way. why you would set up a legal life estate pour travail. Now, let's delve a little bit further into legal life estates. At the common law, English common law, they were called such things as couverture, C-O-V-E-R-T-U-R-E. They were called courtesy, C-U-R-T-E-S-Y, and they were called dower, like dowry, dower, D-O-W-E-R. These were life estates created by marriage. Most of them read O to A, so long as he or she is married to B. Okay? O to A for as long as he or she is married to B. We don't want people to stay married simply to retain property. So, most legal life estates that were in the common law, by operation of modern American law, are now destroyed. Okay? If you look at the property transfer and synopsis, you see that. Today, most legal life estates are destroyed. They're replaced with a joint tenancy, which we'll turn to in a minute. A joint tenancy is O to A and B. In other words, if I want to give land away to my daughter, for long as she is married to to her husband, by operation of modern American law today, I should either give it just to my daughter, because if I give it to O to my daughter, as long as she's married to her husband, and something happens to their marriage, I actually gave the land away O to A and B, meaning both will take a 1/2 interest in the property. Now, what are the duties of tenants of life estates? What happens if you have a life estate, meaning you're only going to enjoy it for your life or a measuring life, the life of someone else? Well, you're allowed to use, to collect ordinary use from it and profit from the land. As a life tenant, you can profit from the land. But as a tenant of a life estate, you need to repair the land. You need to help pay taxes on the land or other encumbrances. You can exploit any type of natural resource on the property. Say the property that you get, O to A for life. I'm A, I'm enjoying my property, and it has rolling hills of apple farms, rolling hills of apple trees. I can produce those apple trees and sell them, and with the proceeds of the profit, I can pay the taxes on it and loosen the land up from any encumbrances that might have been on it before I took possession. So here's the rule. You get to use but not abuse the property. You have to return it to the owner or his estate, O to A for life. You have to return it to the owner, O, in the same or better condition. How can land be in better condition? Well, it can have a lot less taxes due on it, or a lot less encumbrances on it, or a better irrigation system, or, I don't know, what else might you put on land? Nice white picket fences. In other words, you have improved the quality of the property, and that's your duty. Return it in the same or better condition. Let's move on to joint tenancies. Joint tenancies are known for the right of survivorship. The famous one here, the typical one, is O to A and B. We talked about that up top. O to A and B. O to husband and wife. So what happens if A dies? B takes all. If one party dies, the other party takes all. And that is the right of survivorship. That is a joint tenancy. Now, this is different than a tenancy in common. O to A and B, tenancy in common, means that the one part of the property or its value can be inherited by someone else. So if it's O to A and B, tenancy in common, and A dies, B and A's heirs can take the property. Let me say that again. O to A and B, tenancy in common. A dies. A's heirs take half, and B takes half. And then when B dies, B's heirs take the remaining half that B had. So a tenancy in common is literally that. It's in common. One party dies, there's no right of survivorship. The ownership of their part of the property, their half, A's half, then goes down into the heirs of A. One last tenancy I want to talk about, and that is the tenancy by the entirety. We talked about that. It's quite like the legal life estate based on marriage. Tenancy by the entirety is a common transfer of property to both husband and wife. We don't like that. We don't like to force a husband and wife to stay together. Not even for the children, right? They can have visitation. Because if you put two people together and force them together for a long period of time, they're likely to kill each other. We especially don't like that in the state of New York, because one party will be killing another taxpayer. And we can't have that in the state of New York. I wish I could say I was joking, but I'm not. So we have a thing, tenancy by the entirety in the common law. By operation, and it would read like O to A and B as man and wife, or O to A and B, the happily married couple, or O, the husband to be the wife, or vice versa. Now these, the tenancy by the entirety, by operation of modern American law, have been replaced by joint tenancy with the right of survivorship. So, say you wrote O to A and B as man and wife, and they get a divorce. You might be long gone, and it doesn't matter. Because what happens if, say, A dies or gets divorced, right? B takes all. B dies, A takes all. Okay? Now, what I want to turn to is a non-freehold estate, and that's the landlord-tenant relationship. There isn't really a lot to talk about here. Because for those of you who have signed leasing deals, or even the apartments, you've signed something. I'm not sure about the dorm rooms. But in apartments, you've signed a standard form. And what these standard forms seek to do is to eliminate future problems. And they'll even say at the bottom, standard form, a standard apartment form, blah, blah, blah. Right? Because they're really, non-freehold estates are really cut and dry. The most important thing is how to get your security deposit back. Can you sublet the apartment? What happens if you got a hole in the wall? If you're denied power for a period of time or water, can you deduct it from the rent? Things like that are all handled in the landlord-tenant relationship. So, go read the form. There isn't much in this course I could teach you into addition to read the contract, read the renter's contract. But what happens if you don't have a written contract? Remember, express contracts could either be written form or oral. We know that if it's over 1 year, it has to be in writing because of the statute of frauds. Remember? So, the only thing I need to teach you in regard to non-freehold estates is that the term in which to break it. For instance, if you have a year-by-year lease, every year your lease comes up, year-by-year lease, you must give the other party a month in which to cancel. If your lease is month by month, you have to give them a week. If it's week by week, you have to give them a day. Notice what I'm doing? You have to give them part of the whole. A week to a month to a year, a week to a month, a day to a week. If your apartment tenancy is day by day, you actually have what's called a tenancy at will. It can be terminated at any time by either party. A lot of hotel arrangements are like that. You're renting the room for the day. If you want to pull up stakes at 2 a.m. and take off, you can do that, just as long as the day's hotel bill is paid. Okay? So, a part of a whole. And that's really all I need to talk to you about when it comes to the non-freehold estate. And I do believe I'm going to leave it right there because you have a lot to digest. So what I would suggest you do is go read over that property transfer synopsis and take a look at those workshops I posted on Blackboard. And I will also post 2 practice quizzes to help you go through the freehold estate scenarios, the fee simple absolute, the legal life estates, and joint tenancies. All right? And that should be enough to keep you well busy and well educated in the area of property law.